if I see the main exam in this way. So if you can see me project the course outline very briefly at the week 15 is visible in your screens. So alafu anyone it's open for anyone to say anything. Yeah, so I'm the moderator and welcome. So tuanzie wapi? Victor, do you have any opening statements? Anyone? Ama we jump in? Okay. I hope mnanisikia. Hello, mnanisikia?
Victor.
Yeah.
Yes, kama nasema.
Yeah.
Sina kitu ya kukwambia saa hizi.
Yeah.
Not unless you just break down what you want us we discuss on.
So
what I'm certain of is that we cannot discuss all the 15 weeks work.
Hatuendi hadi week 15. We are only doing up to week 4. Unaona hapo hivyo kwa mistake, mispresentation, undue influence, duress, illegality na statutory protection. Hizo tu. Lakini ujue ziko broad na I had planned kuna a lot of things pia mimi nimeplan on my side. So if anyone ako ready to start, anaweza anza ama kama bado nikianza iko sawa, sina issue. How do you see it?
That's all right.
Sawa. So on my end, I had prepared some revisions materials that I had encountered during my revision time. So I start with misrepresentation, and I discovered that kwanza I want to say what the definition of a misrepresentation is. A misrepresentation is a false statement of fact or law. It's just simple like that. And there are 3 types of misrepresentation. Innocent misrepresentation, we have negligent misrepresentation, and fraudulent misrepresentation. Now, what's most crucial in this part, because remember Mr. Roba may ask a scenario question, I decided to go for the criteria that highlights on different kinds of misrepresentation. And the criteria is just straightforward. Number 1, for the criteria, I discovered that false statement of fact or law as opposed to opinion or estimate of future events. So there must be a false statement of fact or law, and mere opinion is not eligible for a misrepresentation action. And the case there that everyone must cite is Bissett versus Wilkinson, a case that occurred in 1927. Brief facts of the case were that the defendant had sold the claimant a land that was to be used for rearing sheep. And the defendant expressed his opinion by saying that he believed that the land could hold 2,000 sheep, of which later turned out it was an overestimate, as the land was small to hold that capacity. So Bissett, the claimant, oh, sorry. So speak. The floor is yours, Victor.
Victor, before you go far,
yeah,
we are tackling the misrepresentation part.
We are?
And that the misrepresentation.
Yeah.
Is the opposite of representation.
Oh, representation. Yeah.
Yes, that is it.
Yeah.
And define that representation.
Yeah.
These are the statements which are made prior to or during the contractual negotiations. So some of these may later become terms of the contract. But when you look at the misrepresentation,
we are together, Victor. We are together. Continue.
Say first, before you go far, anything in this subtopic of misrepresentation, everything are three. Like you'll get that the divination, they come in three parts or three ways. So there are three definitions for misrepresentation. So when we go to the elements of misrepresentation again, it has three elements. And each element has the three cases. So in short, everything in this subtopic.
Victor?
Victor, continue.
Sawa. So thank you for the clarifications. And I was on now the criteria for misrepresentation. And I had started on what one must consider when it comes to answering a technical question when asked. So, and number one, I said that a false statement of fact or law will be accepted as opposed to a mere opinion. And the case that I was trying to explain was on Bissett versus Wilkinson. And in that case, Bissett versus Wilkinson, a case that occurred in 1927, Wilkinson had sold his land to Bissett, and in the process, he had represented to Bissett that the land could hold 2,000 sheep. And that statement proved that it was a mere opinion because the land was never used for any sheep rearing before. And that is what made this statement to be a mere opinion. But if the land could have been used for sheep rearing before, then it could have been a statement of fact. That is criteria number one. I believe it's clear. Then under criteria number two, what I also encountered is a statement of opinion may amount to an actionable misrepresentation where the representation was in a position where the representer was in a position to know the facts. If the representer knows the facts and goes ahead to say that it is a mere opinion, that will not be accepted by the courts. And now, the case that I discovered is the best to use in this scenario is Bartholomew versus Petronida. It's a case that occurred in Tanzania, and it's a very straightforward case in this scenario. In that, Petronida had sold her land to Bartholomew and described the land to be 60 by 40 paces. But in reality, the land was 60 by 40 feet. And Petronida was aware of this position. So, when she tried to raise the argument of it was a mere statement of opinion, the court declined. So, Victor, I see you have raised your hand. Please take the stand. Victor, continue. Yeah.
You are confusing me more as you proceed.
How?
When you started,
yeah,
I told you that you better classify them into three.
Yeah.
As they are.
Yeah.
And at the moment you are still on the statement of the opinion.
Yeah.
I don't know where that statement of opinion falls in. Because the first element of misrepresentation is that we have misrepresentation must relate to the past or the existing facts.
Mm-hmm.
Then if I get you right, you said something on a statement of facts.
Mm-hmm.
And when you started,
mm-hmm.
I expected you to mention that this statement,
mm-hmm.
which amount to misrepresentation, must be the statement of facts. And what I expected you to talk about is on the opinions, intentions, and the statement, the three of them. Then you were in the case of Richard Francis Wilkinson. Then all of a sudden I'm getting you in our case. Can you come back and you try to give the difference between the two so that I can't get confused on what you're trying to give us?
Sawa sawa, Victor, nimekupata. So as I started, I directly said that we will be given a scenario and the lecturer will expect that you will derive some elements from that scenario. So this is not a definite order of tackling the way you have outlined in your notes, because as I've said, these are some specific extractions that I encountered in my research. But it will be fine if we start by how you are outlining them, so that now we will come to know the technical questions that will be asked, and now my points there will apply. If I may take this chance, maybe I invite you to break it down in a manner that I've heard you saying, so that we will not be confused. Victor, please. Victor.
I break them down from where?
Yeah, from where you have said that there are some elements and they are in a specific order.
Okay, what I said is that there are three elements.
Yeah.
Element number one is that misrepresentation must relate to the past or existing facts. That's the first element. And under this element, we say that misrepresentation is not only opinions, intentions, or statement of law. So there are also three there, and that first element. So we have statement of opinion, statement of intention, and the statement of law. Then, number two, we have misrepresentation must be false. Then, number three, misrepresentation must induce the contract. These are the three elements. Then when we come to types of misrepresentation, there are also three. We have fraudulent, negligent, and innocent. Now those three. And each of them has at least three cases. So when you are dealing out the definition of this term, this concept, there are also three. One of them was it's an untrue statement of facts. The second one is an incorrect statement. And the third one is deliberate concealment. So each of them has the cases which explains each of the concepts. Victor, carry on.
So Victor, before you go, I would like you to now break also the cases that are outlined there, because as you have heard, I'm coming to give you how you will extract now the scenarios that the lecturer will want you to break down. I have heard you have a well-organized presentation, and it will be okay if you mention at least one case under those elements that you have referred to. Victor? Ama you are still continuing to plan then?
Victor?
Yeah.
Yeah, let me start with the first one, the definition. Okay. I said there are three approaches to define that concept. One, the first case is the case of Bismarck Fuzz Hallet. The second definition, you get it from the case of Curtis Fuzz Chemical Cleaning and Dyeing Company, which will give you the definition of misrepresentation as incorrect statement. And three, which will give you the definition of the concept as deliberate concealment, is in the case of Gordon versus Silico Company. Is that okay?
Yes, it's okay, Victor. We are all clear.
Now, so the part which you were explaining was on the first element, which says that this concept must relate to the past or existing facts, and you were in statement of opinions. So the first case was on research versus Wilkinson. The second case was the one you were explaining, and the last case is on the Smith versus land and property operation. These are the three cases which explain the statement of opinion. Is it that?
Yes, Victor, we are all clear.
Okay.
So I continue.
Now,
Yeah.
So continue.
Yeah.
Continue now for the second case.
Okay. Okay, thank you, Victor, for that an insightful opinion.
You remember?
Yeah.
That you are still in the first element of misrepresentation.
Okay.
Yes.
Sawa sawa. So as I can recap, the first case that you have had is Bissett versus Wilkinson, and the facts were straightforward. And now the second point that I was in before Victor now came and now narrowed down to what we are dealing with, I was on a statement of opinion may amount to an actionable misrepresentation where the representer was in a position to know the facts. If the person representing this information knows the actual facts, then it can amount to a misrepresentation action to be successful. And the case that I said was Bartholomew versus Petronida. It's a straightforward case because it occurred in Tanzania, and Petronida had sold her land to Bartholomew and said that, and represented to Bartholomew that the land measured 60 by 40 paces. But in reality, Petronida knew that the land was measuring 60 by 40 feet. So when this matter came before the court, Petronida tried to raise the defense on it was a mere statement of opinion. But the courts were very straightforward to say that you were in a position to know the real facts, that the land was measuring 60 by 40. And I believe those two scenarios, by the first being a false statement of fact or law, should be a misrepresentation when compared to a mere opinion as was outlined in Bissett versus Wilkinson, has directly fell under the first category that Victor was stating. So Victor, what was the second categorization? Then I look for the case under my notes. Victor?
The second part under the first element is the statement of intention. Statement of intention under the first element after statement of opinion.
Oh, I've found it. Okay, now under that second categorization that has been risen up by Victor, I found that a statement as to future intention cannot amount to a misrepresentation unless the representer had no intention of carrying out the stated intent. And that has been described very well in a case known as Edgington versus Fitzmaurice. Edgington versus Fitzmaurice. It was a case that had occurred when Fitzmaurice was a company that wanted to sell its shares in order to pay debt, but they had not said that to the claimant. They had said that they want to sell their shares in order to expound their operation, but in real sense they never had an intention of expanding their operation, and instead they wanted to sell the shares for them to pay debts. And it has directly showed that when you had no intention of carrying out the stated intention, then that statement that you meant will fall under misrepresentation. Victor, has that fell under that category?
Yes, very right.
Okay, now proceed to the next element.
You have not finished the next category. Under that first element, you have the statement of law.
Do you have a case that talks on statement of law?
The case of Pakania versus Anki.
Oh, Pakania versus Ankley.
Yes.
Yeah, I have that case. Let me recap now on that. I love the way we are flowing on that area, because maybe without that organization, many people will be confused. And the fourth point in my notes, is on false statement of law will now amount to an auctionable misrepresentation. This case is a landmark case in some way. Let me read you the facts and the citation, the correct citation. The case is known as Pankahania, Pankahania versus Hackney, Pankahania versus Hackney. The claimants had purchased property induced by a representation that the current occupiers of the property were contractual licensees, whose occupation could be terminated on giving 3 months' notice. But in fact, the current occupant was in fact a tenant protected under the Landlord-Tenant Act of 1954. That meant you cannot terminate his occupation by a mere 3 months' notice. It's important you note that. That's where the statement of law comes in. This was held by the court to be a misrepresentation as to law, which had previously been assumed not to be an actionable misrepresentation through analogy, if you compare cases like based on restitutionary claims for mistake of law. When I was doing this research, I encountered another case that was very vital when it came to the distinction between a statement of law to an actionable misrepresentation and a mistake of law. And I won't mention the case because that case is very vital when it comes to mistake. And when I mention it now, it can confuse you. And the case is Claremont Benson versus Lincoln City Council. And just a brief, I won't go into the case deeper because I don't want to confuse you. I want you to know that courts courts will, the rule bearing recovery for mistake of law was abolished in the second case. Now that case I will delve into when we be talking on mistake, but still to remain relevant on what we were discussing, we were talking on as false statement of law will now amount to an actionable misrepresentation. And the case that we were talking on was Pankahania versus Hackney. I believe, Victor, that is also straightforward.
Very true. Then we have the statement of PAF. That's the last one. Statement of PAF. Statement of PAF and advertisement.
Aha. I get you. Now you see, when you talk on statement of PAF, you are subjecting now the statement to a commercial environment. And a mere statement of PAF is allowed when it comes to freedom of contracting parties to either sell or enter into an unequal bargain. And remember, the courts won't help you when it comes to an unequal economic bargain. But a mere PAF will be accepted in some way, but will not be accepted if it comes to economic duress. And Victor, were you referring to economic duress?
No, that's different. I can take the case of Califa's Carbonic Smoke Ball Company. Do you remember that case?
Oh, yeah. Please continue.
And I'll also take you back to the case of Bismarck versus Sallet. Then, I'll also take you back to the case of the other case which you say research versus Wilkinson. So the three cases applies to that scenario.
Thank you, Victor.
Yes.
So I believe by that mere path, I had not captured it well, but after I have heard what you have defined, I believe now in the case of Khalil versus Carbolic smoke ball, it is very open to any law student, and now the facts are very clear in their fingertips. And I'm trying to look it on that case that you have referred me, Bissett versus Wilkinson, on how a trade path will not be accepted if the person had actually practiced that thing before. Like if Wilkinson had kept the sheep and in the process of selling the land told Bissett that this land could hold 2,000 sheep, and in reality he had held sheep 1,500 sheep and he knows that the land cannot hold 2,000 sheep, then I believe that won't be a mere trade path, and now that will be a misrepresentation. I believe, Victor, now we are okay.
Yeah, okay. I think up to that point,
yeah,
we are done with the first element of misrepresentation, whereby you have said that the misrepresentation must relate to the past or existing facts. And when you started, we say that the statement amounting to misrepresentation must be a statement of facts. That is about the existing set of things or past events. And we say that the three sub-elements which you have just explained won't amount to misrepresentation if they are untrue. If they are not true, like the opinion, if they are not true, it not be misrepresentation. Statement of intention, the same thing. Then we come to the statement of law, and finally you finish with the statement of stuff. So now we can move to the second element, that misrepresentation must be false.
Victor, I believe when it comes to that categorization, I had not categorized it on the false part. Maybe if you have a case to support it, it will be okay, because if you mention the case, maybe I'll have it in my notes. Victor?
Victor?
Yeah.
Yes.
So
I have around 3 cases.
Yeah.
And what I can say in this second element,
yeah,
if a person make a statement that is untrue at the time, but later that statement becomes false before the contract is formed, then it's obliged to inform the buyer about the changes in circumstances. So, going back to the case of Dinok for Salad, it will apply to this scenario. By the sale of the farm, it was half true, and there was half false on the status of the tenants who are there. Then if also we go to the case of Gordon versus Sanico Company, there's a deliberate concealment in that case.
Oh, Victor, I've captured you well now, because in my notes that I have outlined that as a duty to disclose a change when it comes to a contract. And the landmark case that I also encountered, to also add on top of the cases that you have mentioned, was HIH Casualty and General Insurance versus Chase Manhattan Bank. This case is a landmark case because it's the one that established now the duty to disclose when it comes to a changed clause and a fact that initially it was true. Now, in this case, I'll be very brief to the facts. And in this case, the Chase Manhattan Bank advanced some sums to finance a film syndicate. The HIH General Insurance provided insurance for the event that the film did not make enough revenue to repay the loan. So in short, if this film was to fail to repay the loan, this general insurance will step up and repay the loan. Chase Manhattan Bank made the insurance a condition of getting the loan and also specified one agent known as HNA. So this bank wanted to be sure that this general insurance can be able to pay the loan when default arises. And the bank went to an extent of appointing an agent known as H&A. H&A obtained the insurance policies but made certain fraudulent misrepresentation and failed to disclose a report that the films were unlikely to make a profit. The films did not generate sufficient revenue to cover the loan, and Chase Bank now sought to claim under the insurance policy. The insurance company refused to pay out, claiming to rescind the contract for misrepresentation and a failure to disclose a material factor in the statement of truth clause. Remember, there was a statement of truth clause, and it was saying that the insured, in this case, the film syndicate, shall have no liability of any nature for any information or non-disclosure by third party, including H&A. And the court held that the clause was ineffective as misrepresentation and non-disclosure was very clear. I believe, Victor, the point of non-disclosure has been captured well in that case, and also in the case of With versus O. Flanagan. With versus O. Flanagan. And briefly, the claimant purchased a medical practice from the defendant. And the claimant was induced to buy the practice by the defendant by a statement that the practice took £2,000 per annum as profits. The statement was true at that time it was being made. However, subsequently, the defendant became ill and many patients went elsewhere. By the time the sale was completed, the practice was virtually worthless. The court's holding was it was a duty to disclose a change, and that amounted to a misrepresentation when the defendant failed to disclose that the practice is no longer making profit after he has become ill. I believe, Victor, by those two cases, the second case is With versus O. Flanagan, has directly answered.
That is the third case.
Yeah.
That is the third case, because you have the first case of Dino Fasalet, second case Gordon versus Selico. Then that case is With Flanagan. Then from that we move to the third element, whereby that element says that misrepresentation must induce the contract.
Aha.
Induce the contract.
Yes.
In that case, in that element, you find I have around two cases. The first case was the case of Eddington versus Fitzmaurice, which I've just gone through. Then the second case is on Atwood versus Small. I don't know if you have the two cases.
On my side, I have two cases also, but not those ones.
Yes, you can add.
Yeah, maybe I add.
I don't know if you have Atwood versus Small. If you don't have, I can go through it.
Yeah, please go through it.
In this case of Atwood versus Small, the claimant purchased a Congress tested from the defendant for 600,000 sterling pounds. Estate contained the mining land, ironwork, and various properties. So many properties were subjected to leasehold and generated income. So mine were to be worked by and profits to go to the claimant. So the preliminary agreement was made between the parties, whereby the claimant agreed to purchase subject to being satisfied that the report and the accounts given by the defendant are accurate. So claimants and accounts and directors checked and were satisfied with to be correct. So claimant proceeded with the purchase. It transpired that the account had been exonerated and the claimant sought to rescind. So the court held that claimant was unsuccessful and getting his own expert to check the account and report had not relied on the account but on his own judgment.
Wow. So can I add also mine? So in that.
Carry on.
Okay, thank you. So as I add, remember this is an inducement stroke reliance rule that will also lead to a misrepresentation. So I have two cases. Number one is Hofsfall versus Thomas. And in this case, a gun with a concealed defect did not induce the claimant to purchase the gun. So if you can be able to deduce from that statement is that Thomas had sold Housefall a gun and the gun had a concealed defect. But because the claimant never saw the concealed defect, we cannot say that the defect was the one that induced the claimant into entering the contract. And now the grounds of the claimant will fail on that perspective since it never induced the claimant into entering the contract. And the second case is Redgrave versus Hard. I also heard Victor mentioning about this case. And Redgrave versus Hard, it was a solicitor had purchased into the partnership in the solicitor's firm, and he had been told that the firm will generate an income of £300 per year, and an opportunity to look at the accounts was also provided to him. But the claimant never looked on the accounts because he relied and believed that Hard was correct in what he was saying. And the income in actual sense were £200. And the court's holding were that Redgrave was entitled to indeed receive the contract on grounds that the £300 had induced him to enter the contract, to enter into the contract. And I believe at that point, the two cases are an additional to what Victor had earlier discussed on. So Victor, what's the next now criteria, or I jump into the next thing? Or if Victor, you don't have anything, Naslata and Albert and Jared, in the meantime, if you have anything, you can also contribute.
Give the chance to the others.
Yes.
Then I will proceed after them.
Yes.
After Kimoni, C, and Charo.
Yes, I've directly mentioned them. So anyone with something to add, comment, question? Naslata, Jared, and Albert. So you are okay if we continue? I see Albert saying, he is okay if we continue. Naslata, Jared. Okay. Victor, now continue to the next part.
The next part will move to what is the last part on this concept of misrepresentation. That is the part where I also told you that I classified them into three, whereby we have the types of misrepresentations. And the first one was fraudulent, then negligent, and finally innocent. So Victor,
yes,
can move on. We can start with the fraudulent one.
Yes, I'm ready with the fraudulent one. Then you'll tackle the innocent. Is it okay?
Yes,
okay. Okay. So for the fraudulent misrepresentation, I will give the landmark case in that area, and I will start by the citation, then the facts, and the tests that were put forward in that case that will directly lead you to a conclusion that that is an adequate fraudulent misrepresentation. And the case is Dairy versus Peak. And in this case, Peak was a company that was dealing with transport services, and they had invited the public in their prospectus, and that they had stated that they will be able to drive horse-driven carts, and now they will upgrade to train-driven carts. And they had said that on belief that they will be given a trade license by the Board of Trade in that era. And it later turned out that dairy had relied on that prospectus and had applied and also bought shares on those grounds. And what convinced the judges in this case is that PIC was honestly believing that they will be given a license to operate the train-driven carts, and instead, the board declined to give them the license. And now you can see the implication that it will cause to dairy after believing and also engaging into it. And now, the judges had to provide an acid test that will set forth what we call a fraudulent misrepresentation, because in that case, PIC was not liable since he had honestly believed that the Board of Trade will grant them the license and they will upgrade from horses-driven transport to a modern transport means. And now the three acid tests include: number one, that statement made either one, knowing it to be false, that is one requirement for a fraudulent misrepresentation, and number two, without belief in its truth, and number three, recklessly or carelessly as to whether it be true or false. Those are the three tests that will directly result in you saying that in that scenario, there is a fraudulent misrepresentation in the vicinity, prima facie. So I believe in that discussion, I have directly explained on my part. Victor, if you can continue.
Just want to give the literature part on innocent misrepresentation. And you find that a person makes a false statement believing it to be true, having a reasonable ground to believe that it is true at the time when the contract is concluded. And the statement is made when the party that made it honestly believed that the statement which was being made was true. So you find that the damages are awarded for the fraudulent misstatement, misrepresentation, or negligent misstatement, but no damages are awarded for the innocent. So sometimes, if the court may give indemnity to the victim of the innocent misrepresentation by allowing him to recover any expense incurred by performing the contract induced by this kind of misrepresentations. So, don't know if you have any case to guide us on that, Victor.
Maybe I'll respond to it later, because at the moment I had prepared on fraudulent misrepresentation, but I believe I have a case to support it. So at the moment we can be continuing to the next discussion. And what will be the next cover? Remedies. Oh, for the innocent misrepresentation, I discovered that I had written something. And maybe I can read it verbatim before we go to the remedies and misrepresentation. And I had written that an innocent misrepresentation is an untrue statement made in the honest belief that it is actually true. Before 1963, the only remedy for non-fraudulent misrepresentation was rescission, and damages were not available at that time. However, in 1963, the House of Lords changed this position by stating in the obiter that in certain circumstances where negligent misstatements resulted in a person suffering harm, damages may be recovered in tort, as was held in the case of Headley, Hiller, and Partners case. And now by it is very visible and clear that when it comes to innocent misrepresentations, the court have been so reluctant to award an innocent party damage as a compensation. And Victor Kapkoris had outlined that point clearly And to an extent, they have gone to calculate the cost that the person had suffered when compared to the actual market value. So it has been an area that has also attracted the thought of deceit on its own, and has also included negligent misstatements, as was evident in Headley, Hiller, and Partners case. So I believe at that scenario, if I find another case, landmark case, that directly talks on innocent misrepresentation, I'll bring it on board before this session is over. And Victor, now we can continue to the, I believe you said remedies, or?
Yes, I said remedies. We move to it.
So remedies, what kinds of remedies are there for misrepresentation, Victor?
I found only two: damages and rescission.
True, there are also two on my side. Unless anyone else has a contribution. Okay. So what will be the next part? Is everyone okay with misrepresentation before we jump to mistake? Everyone okay? Aya, Victor, I believe everyone is okay. And what do you have to say when it comes to a mistake as a vitiating factor?
I think we should.
Yeah.
We should take questions.
Okay.
We should take questions.
Okay. Any question? Jared, Naslata, Albert, and the rest? Any questions?
No questions.
Okay, thank you. Victor?
I just have one question. Huh?
Yeah.
On you say that we have two remedies.
Yeah.
Rescission.
Yeah.
What factors affect this rescission?
What factors affect this rescission?
Which factors make rescission to be effective, to be effected?
I believe if a party has delayed to claim rescission, then being misrepresentation will be voidable in some way. And if you delay, the court will assume that maybe you wanted it to occur and you kept quiet. Because there is a case on Long versus Lloyd where the defendant had sold his lorry to the claimant. And the lorry immediately stopped functioning after the sale. And the defendant said that I will make this lorry for you for free. And the claimant agreed. And now then the claimant continued operating with the lorry, and now the lorry again broke down. And in this time, the claimant, when he tried to reach out for the defendant now declined to assist. And when this matter came before the court said that because you had taken so long, it looked like you hadn't really accepted, and now the rescission remedy won't be applicable to you. So it looks like, and deep down kwa ground, you know that you actually want to buy something with an expectation that maybe it will be better with time, but in reality, the courts will assume that you have forgone your right of rescission. So I believe, Albert Charo is also saying, are there circumstances under which rescission is not allowed? Yes, if you overstay in time and maybe other factors. Victor, if you have any other factor to include. I am also seeing a formation of contract from Albert Charo is also one ground of you foregoing your right for rescission. And also remember, if you bring an agent into the contract to look at the particulars of the contract on your behalf, the courts will also deal with it as if you had affirmed to the contract. And now your right of rescission will have been foregone by the emergence of that agent. So Victor,
so there are two factors, in that case, affirmation of the contract and unreasonably long period of time.
Please mention them, Victor.
I've just seen what Charo has posted there.
Yeah.
We have affirmation of contract, and what you are explaining was on a reasonable long period of time.
Continue, please.
But if that person, what I mean is that from what you are explaining, and in that case that you gave, if a victim wait for an initial long time before taking the action to leave the contract or rescind the contract, his right to rescind may be lost, and that can happen in the cases you are giving. That case which you have just read.
Long versus Lloyd.
Leaf versus international galleries.
Oh, there's also the leaf. Please continue, sorry. So the case that you are, I was looking for you was the leaf versus international stock galleries.
Yes, that's the case I'm telling you, which gave us, if a person stays for a reasonable, a long period of time, the contract will, that right to rescind the contract will be lost.
True, Victor. Do you have the facts of that case? Maybe the people will want the facts.
Unless I check before you leave,
yeah.
I'll give you the facts.
Oh, maybe. Oh, maybe I have it here. Let me look for it. A moment. So we can also be continuing as I look up on the case on my side. So what do you have to say when it comes to other areas on misrepresentation before we proceed to the next vitiating factor? Anyone? I believe I found the case, the Leaf versus International Galleries. It was a case that occurred in 1950. And in this case, the claimant purchased a painting from the defendant. Both parties believed that the painting was by the artist Constable. In fact, 5 years later, the claimant discovered the painting was not a Constable. The claimant brought an action based both on misrepresentation and mistake. The claimant based on misrepresentation was successful, however, since it was an innocent misrepresentation. The claimant had lost the right to rescind the contract through lapse of time. With innocent misrepresentation, the time starts to run from the date of the contract, not the date of discovery. The claim based on mistake was unsuccessful as the mistake related to the quality and did not render the subject matter something essentially different from that which it was believed to be. He believed that he was buying a painting and he got a painting. I believe also the case of Leaf International Galleries of 1950 will also answer the area that you are asking on an innocent misrepresentation for a case law. So I believe the case will kill one bird with two stones. So please continue. Anyone with a suggestion, question? So I believe all is set and clear at that point. So we'll also look on other areas, the technical areas on what the courts have tried to expound on when it comes to allocating an innocent, misrepresented party a damage. Why are the courts so reluctant to allow an innocent party, and yet it was just a fault that occurs normally in businesses? So anyone with something, a question, comment? If no, then we can jump into duress or a mistake. Which one is easier? So Victor, I see you have raised your hand. Please go on.
I thought we had said we look at the illegality of the contracts.
On illegality, Victor, yes. I had not prepared because there is some steps that you have to quote when it comes to illegality, and I believe they are very straightforward. Do you have them on your side for you to read it? Because I believe the illegality is also statutory. Yeah.
Maybe Jared is prepared. Ask Jared or Nas.
Jared, Naslata, Albert, who has those some kinds of
The contract.
Yeah, that will render a contract illegal. Jared, Naslata, and Albert. What do you have to say? Anyone? Albert, Naslata, Jared. It's okay. Victor, do you have the provisions on illegal contracts? As I'm looking on it right now on. So I believe I found it. And if I may jump into it, remember the illegal contracts have been divided into two. There is by statute and there is by common law. So by statute, I won't delve into that much because whatever a statute has said it is illegal, it is directly illegal. So that is straightforward. Now, if we go into the common law category, I believe now this is where we have some breakdown of the same. And if we are looking at the breakdown, number one will fall under what we call contract to commit a crime or a tort or a civil wrong. So this is an obvious category and it has been also straightforward. If you were planning to commit a tort, let's say of trespass, something, that is a straightforward. And there is number two, contracts that prejudice public safety. Contracts between nationals of two countries that are at war with one another falls under this heading. So I believe that is also straightforward on your end. And number three, we have contracts affecting the administration of justice. Remember that efficient and impartial justice is a sign of a healthy nation, and therefore any contract designed to interrupt that state of affairs is certainly illegal and probably also be a crime. And if I can mention a case here, it is Scott versus Avery. It says that a policy of insurance provided that no action should die in a court of law until the decision of an arbitrator had been obtained. The House of Lords held that the jurisdiction of the courts had not been excluded and that reference to an arbitrator was merely a condition precedent to the right of action. So in that case, it has been defined that if you want to enter into an arbitration clause, the arbitration clause will not alter the jurisdiction of courts when it comes to administration of justice. So in short, if you come to common law, the law says that contracts affecting the administration of justice will be illegal on those grounds. And the next points that we must also mention when it comes to this common law area is that contracts that tend to promote corruption in public life will also be illegal. And if we can also look now at the next area, is contracts to defraud the revenue, either local or national, will also be an illegal contract. If you are planning something to you will skip KRA, that will be an illegal contract on your end. And now the next also point that we must also state is contracts having a sexually immoral base. If you have rented your house for it to be used for prostitution, and maybe prostitution is outlawed in your area, like in the Middle East countries, then you cannot go before the courts and enforce let's say like rent to be paid to you, yet in the first place it was a sexually immoral base and it has been outlawed. And now the last point, if I'm not wrong, is a subsequent or collateral contract founded on an earlier illegal transaction is also tainted by the earlier illegality. So if your initial contract was illegal, then it's collateral. The second contract that you want to form will also be illegal. And maybe this point will also capture those persons who have evaded tax and they want now to clean their money through money laundering. And now in the process, they want to enforce a collateral contract, maybe with a property estate. So that second contract, even if it's cleaning the money that they had obtained by defrauding KRA, the second contract is still illegal. And I believe at that point, I have clearly outlined on illegality when it comes to contracts. Anyone with a question or a suggestion can continue. Hello? Hello? Yes, so anyone else with something to say? So I believe in this comment section area, there is the Leaf and versus International Galleries. The facts have been reiterated there. So there's nothing I've missed in that area. And if I can look something, please. So allow me to leave this area because it's a wide area and we can also revisit in some time. And at least at that point, we have outlined misrepresentation and illegality very well. And if I can be allowed now to jump into duress, or if anyone else has a comment or question, then we can hear on his part or her part. Victor, I'm saying, hello?
Yes, Victor.
I'm saying that let me jump into, because I had prepared on this area, Pia. It's important that I just finish on it. I had prepared also to talk on the test when it comes to economic duress. Because remember, economic duress will be an area to be tested. And it is important, maybe I highlight the case, the landmark case, and the students will leave the student to the assignment on checking the landmark case. So everyone just go, because we will also have another meeting on contract law where we'll discuss on undue influence and mistake. Everyone please go and check the case of North Ocean Shipping versus Hyundai Construction. And that case is a landmark case when it comes to economic duress. And then we'll begin from there and outline the test that must be encountered before an economic duress is awarded. So anyone with a closing speech mark or a comment? Because the next meeting I want us to discuss on partnership law at this time. So that's where you have seen us not entering into mistake and undue influence. So anyone with something to say, conclusion? If no, then asanteni kwa kuja. So do you want this the same, Victor? Victor, Victor. Yeah, I was saying, so yes. What time do you want the second meeting of partnership law to take place?
6 p.m.
6 p.m. Sawa sawa.
Yes.
So let us take this break. Everyone prepare, then we'll be back. Asanteni.